Shautsova, immigration attorney from New York, is here. Today we're going to have our live when I will be sharing with you certain tips that may help you in your various cases. We're going to discuss USCIS, marriage-based adjustment of status cases, and practices that have been recently implemented by USCIS with regard to those cases. We're going to talk also about DS160 non-immigrant visa applications and what you can do if you made a mistake on an application. I think this is something that is of interest for those of you who are willing, wanting, dreaming about filing for a visa in the United States. It's a very practical, very interesting tip that I will share with you today. So thank you very much for joining me. Please let me know where you're watching from. Let me know if you can hear me, please. Hey, Eric. Nice to see you all, guys. How is your Saturday? How is your Saturday? And don't forget that in the end of my presentation, we are going to share opinions, questions about something that's of your interest, right? I'm going to be answering your questions. So thank you very much, guys, for joining, and let's start. Well, first of all, I wanted to let you know that if you are somebody who is thinking about filing for adjustment of status based on marriage right now, and you can present a very strong paper case, you are in luck. Why? Because recently USCIS started waiving USCIS adjustment of status interviews based on marriage. And I mentioned that in one of my previous videos, but I wanted to focus this video specifically on this point. So, of course, not every interview is going to be waived, but many will be waived if you have a compelling case, right? Many years ago, when I just started practicing immigration law in the United States, there was an opinion among several immigration lawyers, well-known immigration lawyers as well, that you do not have to submit anything for your immigration case apart from your marriage certificate and immigration forms. And if USCIS has some questions about your case, they will let you know. And typically such filers would present evidence only at the interview. Of course, back then, interview would never be waived. But I, for example, never followed that approach. I always advise my clients to present your strongest possible case from the very beginning, right? Why would you want to do that? Well, there are several reasons for that. First of all, if you present just empty forms or just forms, you may trigger USCIS investigation into the situation, into your marriage, even prior to your interview, right? Second, what if something goes wrong between the spouses, and later one spouse would like to proceed based on VAWA, for example, or they will still proceeding based, let's say now, on a new marriage. However, USCIS, don't forget, may always ask you to present evidence that your first or ever marriage in the United States was real. And guess what? You're going to be starting this immigration case, exposing yourself to this review of your life, of your situation in the United States, but you're not going to be filing any documents to support that your marriage is real. And later something goes wrong, and now you are on your own. You have to proceed by yourself, but you and your spouses were never working to collect the documents. You were never preparing yourself to have that evidence that the marriage was real. And trust me, if you guys break up, it's going to be very difficult to find and collect the documents. Of course, some people will have, just because maybe they heard online or they did some research, they will have some evidence, but some people will not. I meet time after time situations where people cannot present evidence of real marriage just because they thought that they do not need that evidence. They didn't think it was important, like, for example, filing of joint tax returns or utility bills or a lease showing that both of you residing in a same place, and people later find themselves in a lot of trouble. So for that reason, I never advise my clients to do just the bare minimum form filing. I always would present the case in the best possible way. Remember, there is always something you can present, even if you have just a very fresh marriage. And we're going to talk about this, of course. But the point is that now people who chose the second strategy, when you present and build the case at the very beginning, the strongest case, now those people are in luck because USCIS decided for some of those cases, they will be waiving interviews. And of course, interview saves you money, saves you time, saves you stress, and speeds up the case. The cases based on marriage are being processed much faster. I've noticed faster receipt of travel authorizations, work permits. So now if you have a strong case and you really prepared your case, got some necessary documents, and again, I have videos about what documents typically you would want to present for USCIS review. The same list, guys, nothing special, the same list that comes from instructions to the form I-130. If you have a strong case, you may have your interview waived, which is terrific, right? Which is terrific. Now it's a good time to use this opportunity to file your cases. So now a little bit about what documents you would like to present. Typically, and what to present if you just got married, right? What if you just got married? So anybody who just got married, guys, can present at least 2 affidavits from US citizens or green card holders confirming that their marriage is real. This is doable. This is doable, right? That's number one. Number two, anybody who just got married may present pictures, photos of your wedding, photos of you guys spending time together. This is doable. There is no excuse for you not to produce that. Some people are struggling with opening accounts because they don't have social security number. Some people are struggling with the fact that they for some reason they cannot get utility bills reflecting 2 names on the utility bills. Why that would happen? You live with your parents or you are renting an apartment and pay cash, and the price includes everything, and you don't have to pay separate utilities. Yes, it's possible. But in this situation, get a letter from the person who are you renting, even if it's a free rent, right? From the parent who is, or family member who's allowing you to live in their basement or in their apartment, from the landlord who can confirm for the purposes of your immigration case that you do reside together and that this payment includes all the utilities, right, and all the expenses. So this is doable. You can do that. So now we have photos, who have letters from a landlord or person who is allowing you to use their apartment to live there. And of course, you have 2 letters at least from friends or family members. So you see, even very fresh case may have at least some evidence, guys. And of course, you can use your social media posts showing how your relationship was developing, if you have any. Of course, the best evidence is if you have a copy of the birth certificate for your baby, right? But not everybody has it. Not everybody at that stage in life that they're thinking about children, right? Maybe somebody does not want to have children. It's totally fine. It doesn't mean that your case is going to be denied. It just means that you have to sit down with your attorney and go through your life and determine what is it that you easily can produce, showing that you guys have life together. So this is something about USCIS. Now, useful tip for those who are going to be filing, who filed already and waiting for the interview with regard to their non-immigrant visa. Pay attention, guys. So when you're filing for your visa with the US consulate, it's extremely important that you provide the most accurate information. You cannot make mistakes with regard to your employment history. You cannot make mistakes with regard to your marital status, whether you're married or divorced or single, about your children. But what to do if you did make such a mistake? Somebody helped you to submit DS160 form, and you, in tears, realized before the interview that there is a mistake on the form, right? what are you going to do? You are trying to go back to the system, trying to open that DS160 form that you filed to correct it. And guess what's going to happen? You will not be able to do that. The system is locked. Your application is locked. What are you left to do? And here is a tip. It's actually very simple. When you're going to come for that interview, there will be an intake clerk. This is the first person that you meet when you are arriving at the US consulate before you're going to meet the consul himself or herself, right? The person who's going to actually do your interview. And with that intake clerk, you can make corrections to your application. Extremely, extremely important. The person who meets you first and asks you first questions has an opportunity to reopen and unlock your DS160 and make corrections. By the way, the person who's going to do your interview may make corrections as well. However, here is the tricky part. If they ask you a question of some sort and there was a mistake, you say, well, there was a mistake and this and that. Very often it leads to accusations of misrepresentation or fraud. So please, if you made a mistake on your form DS160, make a correction with the intake clerk. So now you know how to avoid mistakes and how to not get yourself into trouble, right, in the future. And now, guys, after I shared this useful information with you, I hope you find it useful. So please like and share the show. It would be very helpful for me to grow our channel. And of course, I am very grateful for all of you for supporting me and for joining the channel. Sharing the information, sharing our news. Thank you very much, guys. I have the best followers, best social media family. Thanks to you. I'm here. So please, thank you very much. If you like the show, like and share it. And now I'm going to be answering your questions. I sincerely hope all this time you were able to hear me, because if you were not, it will be a disaster. Hi, Ali from Chicago. I think Ali joins me every time. He's one of my most dedicated followers. Thank you very much, Ali. Hi, Baba. How many PD requests can people file? Well, I don't think there is actually a number as to how many requests you can file. But if you are basing your request on the same facts and same documents that you already presented before the prosecutor, I don't think it's going to be wise for you to refile it, right? If you updated your request, if maybe your venue changed, maybe political situation changed. I had a case where I had to file and refile those PD requests several times because we first started working on the case when there was Trump administration and PD requests were generally a denial, but we did try several times. Then the venue of the case changed and we again filed the PD request, now with a new prosecutor. And then the administration changed. And once the administration changed and we refiled the request again, it was like fifth or sixth time, it was granted. So persistence and knowing what is it that you're looking for. But there is no really number as to how many times you can file a PD request. Thank you very much, Praveen. Thank you, guys. Thank you, Sunil. Hi, Kumar. Thank you very much. Hi, Rahul. How can I find out, probably, right, about the work permit in the United States? Excellent question. Well, I have a video about this, actually, as to how to receive a work permit in the United States. But quickly, I'm going to tell you that to get it, you either have to qualify for a work visa and being sponsored by an employer in most situations, or an investor. You can qualify as an investor, or you have to be filing for some benefit in the United States that allows you also to file for the work permit in the meantime. For example, asylum, for example, adjustment of status. But of course, you have to also qualify for the benefits you are seeking. This is how it is going. But unfortunately, in the United States, there is no opportunity to file just for the work permit. I don't know why, actually. I think it wouldn't be a bad idea. Hi, James. Hi, James. How can I come there? Can you show me the details? To come to the United States, you have to also qualify for a visa, right? Immigrant or non-immigrant visa. On my website, www.shautsova.com, I actually have a link. The link says how to come to the United States. So it's very easy to receive free initial information. And if you believe that you may qualify for one of those routes, you're welcome, absolutely welcome to call us, make an appointment, and we're going to discuss with you in details if you actually qualify for one of those. Hi, Rai. Hi, Raj. Hi, Mohammed. Hi, LA. Hi, Alena. Does one have to wait for 3 years after becoming a US citizen through naturalization to be able to adjust of status for someone like their parent? All right. So does one have to become 3 years after becoming a US citizen? No, you do not have to wait for 3 years after you become a US citizen to file for your parents. You can file for your parents the next day. What happens, however, and I think it's like a mix up a little bit, if you marry a US citizen and you get a green card, right? After you maintain this green card status for 3 years, then you can file for naturalization and get citizenship if you still have a viable marriage, right? Okay, but after that, as soon as you become a naturalized citizen, you can file for your parents. This is how it's working. All right? Yes, because unfortunately, a person who is just a permanent resident cannot, under the United States laws, sponsor their parents. I don't know why. All right. Guys, always ask me about WhatsApp. We do not use WhatsApp at this time. We just do not use it. We do use phone system, email system, Skype, Facebook Messenger, Instagram Messenger, and YouTube comments. That's what we're using. Hi. It will be in NBC. Hi, Eric. Does acceptance I-140 affects I-45 also? What should I do if my AP and work permit hasn't approved yet, also 8 months passed? Eric, you can file I-45 only if you have grounds for it pending or filed at the same time, right? So you wouldn't be able to file I-45 if your I-140 was not accepted. You stated that you're waiting for your work permit and for your advanced parole for 8 months. Well, your case is based on employer petition, not on the marriage, so it doesn't surprise me. It does take a very long time for work permit and advanced parole to be granted, ordinary, when you file for adjustment of status. Maybe you qualify for an expedition of the work permit if you are in healthcare industry or childcare industry. And it's, by the way, it's a very broad definition. It's not just for doctors and nurses. It's also for support staff, people who work in retail, selling medical supplies, and so on and so forth. But yes, it's going to take a long time otherwise. And, again, I think it's more the other way. I-45 depends on I-140. If it wasn't I-140, you wouldn't be able to successfully file I-45. All right, do we have more questions? Let's see. Somebody asked me the last time and I couldn't reply to them about asylum and if there are any news in asylum cases. Well, my whole past life was about asylum. Asylum cases that were filed in 2016 are being called for the interview, guys. So are the newly filed cases. And in my past video, I was giving tips as to what to do if you were waiting for your asylum interview for a long time. You have to review your filings. You have to supplement your filings, updated evidence, perhaps, updated country conditions. And of course, you have to prepare for the interview. If you filed your case in 2016, I think now would be a good time to review what you filed, because it's been like, what, 6 years ago? And see what is it that you can supplement your case with. All right, you have to start getting ready for your case. Other than that, I wouldn't say that there are some changes, big changes in asylum filings. I cannot say that asylum interviews will be waived, guys. Like for marriage cases, unfortunately not, right? Unfortunately not. Asylum cases are based on your testimony. You are very often the only and the most important witness. And for that reason, I never ever heard of cases where asylum interview can be waived. Okay. Okay, thank you very much for watching again. If you like the show, share it, please. Help us to grow our channel. And don't forget to join us next time so we can discuss more interesting topics and questions. And I hope to see you soon.